Hello and welcome to The Big Picture. The black money debate in this country has been on for some years now, with it getting politicized lately. The politicization of the debate has completely overshadowed the complexity of the issue. In the bargain, the debate has veered towards speculations about which politicians or industrialists must be having accounts where and to what extent. Meanwhile, the intervention of the Supreme Court following petitions in 2009 and its order in 2011 that all names of the Indian account holders in Liechtenstein Bank be disclosed created an entirely new dimension to the debate. The UPA government in April 2014, just it was voted out of office, disclosed to Supreme Court 26 names. Yesterday, the NDA government disclosed 7 names. Unhappy with it, the Supreme Court today sternly directed the government to disclose all the names of the account holders. It has also refused to entertain the government's plea to modify its 2011 order. The government had claimed that it could release names in tune with international standards. However, Apex Court has rejected it and asked names to be disclosed by tomorrow. What are the implications of this order and what are the real issues behind this debate? We will discuss all this with a distinguished panel of guests. I have with me Professor Arun Kumar, Center for Economic Studies and Planning, JNU, and an authority on black economy and black money. Arvind Virmani, a distinguished economist and former advisor in the Ministry of Finance, Government of India. Sanjay Hegde, Supreme Court advocate, and Paranjoy Guha Thakurta, a senior journalist and economic analyst. Welcome to all of you. In fact, Sanjay Hegde, I would like to come to you first because there's this order which has just now come today now of the Supreme Court saying that all names be disclosed. What does it mean? The government, this government, the previous government had said that we can't disclose all the names unless and until there is, there are any cases against them and each case has to be seen and things like that. Now that the Supreme Court has said this, what does it imply?
The government is in a tough place. It has to comply with the Supreme Court order because the Supreme Court's order is binding on everyone here. It has to hand over the data as it is, the raw names in a sealed cover. That's what the Supreme Court asked for. The Supreme Court has today indicated that it will decide its own course of action, including giving further directions to the SIT as to how to act on those names. The government may then, at a later date, have to satisfy the other countries with which it has DTAs,
right,
that it has in fact complied with the DTAs, has not breached confidentiality. As to how the government proposes to reconcile both, that is a tricky question and we shall have to wait and see.
Okay, Mr. Virmani, you have been in the Ministry of Finance, you may have been familiar with this entire issue. Do you agree with Mr. Hegde that government is in a dire straits now?
Well, my understanding of the DTA is public disclosure. I am not sure what the position of sealed cover to the highest judicial authority is, frankly. My suspicion or my guess would be that should not be a problem as long as they don't give it further to somebody who the government is unable to give to. So, for example, if government was investigating, it would have to direct certain investigating agencies. If that is all that is done by the Supreme Court, okay, investigate these 6 names.
Give it to the SIT.
Not saying that these are the names we have got from here or there, but do an investigation of these 6 people to see whether there's a prima facie or whatever. I mean, legal, you can ask them, I don't know the legal position. But as long as it follows a similar procedure to what the government would be expected to follow, I would guess there is not a problem. But if it follows a different procedure, then there could be a serious issue. And some countries might say that in future we will not give any such names.
What was the problem? During the UPA government also this debate went on, on and on. In fact, and the UPA government had taken the same position which I think this government also took in front of the Supreme Court, saying that, we have to follow certain international standards. We cannot, unless and until there is a criminality or evasion is established, we can't just bracket everybody under the same thing. What was that problem?
See, let's understand what's a DTAA. You see, it's a double taxation avoidance agreement. So if I have an income in Switzerland and I am taxed there, then I don't have to pay a tax here. So it's about the declared income. It's not about the undeclared income. So it's nothing to do with black incomes at all, because those are not declared either there or
One
here.
second. This list which from the
No, so I'm coming to the list.
Liechtenstein bank list.
Yes, I'm coming to that.
No, one clarification for the people, for the viewers also.
Yeah.
Are the names which are there in this list, are all of them established as having money which was not accounted for?
No. Nobody says that they were accounted or unaccounted. They had bank accounts there.
They had a bank account.
They had bank accounts. And this data was stolen by one Mr. Kleibe of the LGT Bank and sold to the German government for 4 million euros. There were American names, French names, British names, Indian names. And the German government offered it to everybody. Indian government refused to take it in the beginning under Supreme Court's pressure that these names were taken. Now, the question is, does the DTAA apply to this? It doesn't apply because it's not about an income in Germany or an income in India. It's in a third country bank which the data was obtained from them and given to Germany, and Germany then offered it to India. And then the Indian government later on took it. Similarly, the HSBC, the data which is now being talked about where these names are coming out, the HSBC data was stolen and sold to the French government.
Right.
So it's not about income in either France or in India. It's about bank information in Switzerland. So the DTA of Switzerland may come into play, but the DTA of France does not come into play. The second point that I'd like to make is that there are several DTA...
One second, one more clarification I want. Swiss banks, according to the Swiss banks rules or
this is HSBC
regulation
in Geneva. Yeah.
I know, but the Swiss bank rules or, their what they have been following, it says that illegal acquisitions of this kind of data, they will not...
So that's why I said the Swiss DTA may come into play here, but the French DTA doesn't come into play because it's not the data about income in France. Okay? So now when the government of India approaches Switzerland and tries to get additional information from them, then this begins to come into play. But as far as revealing the names to the Supreme Court is concerned, the DTAA between India and France should not come into play. Secondly, the secrecy is not absolute because, as I'll read out, it says may disclose the information in public court proceedings or in judicial decisions.
This is the double DTA agreement?
This is the DTA agreement with Germany, with France, with USA. The USA one in 1970 formed the basis of the DTAs that were signed later on between various other countries. Okay, so this particular clause I've seen in many other DTAs.
This also applies to the Swiss?
In a slightly modified form, it also applies to the Swiss. And with the Swiss, we had a revision in 2009. So there was the earlier DTA and the later DTA. And in the later DTA, this kind of clause is there. Disclose the information in public court proceedings or in judicial decisions. So what goes to the Supreme Court would come into play in court proceedings. Okay, and if it is given to SIT, because the SIT is being set up by the Supreme Court order, therefore it can also be given to SIT, and SIT is going to investigate this tax matter because here the authority has been given by the Supreme Court, and in all the DTAs I find that this information can be given to tax authorities. Okay, so therefore giving to SIT should not pose a problem. It is the problem maybe giving the information to Ram Jethmalani, who as an individual has been demanding through his petition in 2009 that these names be revealed to him. So the distinction that has to be made is whether the names can be revealed in public to Mr. Jethmalani or it can go to the SIT. I think to the SIT there should be no problem.
So what the Supreme Court has ordered today is completely in tune with what?
Yes, I think that should not pose a problem as far as the DTAA is concerned. And most DTAs have something called a clause 24 or clause 26, which is about exchange of information. So as far as the main DTA is concerned, there is no secrecy. It's in the exchange of information that the secrecy clause comes in. And my argument is that as far as France is concerned, it's not giving information about income in France. It's about information in a bank in Switzerland. And therefore, that should not pose a problem.
Mr. Virmani?
Well, my point was only that if one agrees with what he said, that it's a problem with the Swiss DTA, then we have to look at the Swiss DTA and see, because we know that Switzerland has very strong secrecy requirements on its banks. That's just a fact.
Was that
so
the
we
problem?
really have to...
Was that what stopped the UPA government from releasing the entire, disclosing the entire list?
Well, the talk that I have heard is about the Swiss.
But the point is that the Swiss, I was reading out from the Swiss DTA, the modified 2009. There also it's very clear, disclose the information in public court proceedings or in judicial decisions. So therefore, as far as the Swiss DTA is concerned, giving the data to Supreme Court or from Supreme Court to SIT should not pose a problem because that's what is in the modified treaty.
Okay, Paranjoy,
You know, I was just listening to what the speakers before me were saying, and I want to try and clarify the legal position to the best of my ability. And I'm relying heavily on an article that was written by the former Additional Solicitor General of India, Vishwajit Bhattacharya, in the Economic Times it was published in the Economic Times on the 25th of October. First point. And this is, you know, for instance, tax evasion is not a cognizable offense in Switzerland. It's not a crime, unlike in India. But even within India, the way the law as it exists today makes things very, very confusing and complicated, and shows you that there is far more politics in what is going on than hard economics or even law. Firstly, it's not a crime to maintain an account. An Indian citizen, whether resident or non-resident, can maintain a bank account outside the country, and including in Switzerland. Now, on the 1st of June 2000, the Foreign Exchange Regulation Act ceased to exist. It was replaced by the FEMA, the Foreign Exchange Management Act. And under the FEMA, a criminal offense, you know, became a civil contravention. So a violation of FERA was a criminal offense, whereas a violation of FEMA is a civil contravention. That's the first point. In other words, nobody can be prosecuted criminally for violating FEMA. Now, what you have two agencies. You have the Enforcement Directorate and you have the Income Tax Authorities. And let me try and tell you why it is so difficult that despite all these claims that are being made by the government, it's going to be extremely difficult to establish criminality or the violation of the law and thereafter bringing back the proceeds of the crime. It's a separate matter that Indians may have parked ill-gotten proceeds, illegally acquired assets outside India. It's a separate matter that much of these assets may have already returned to India after it's been laundered white through various tax havens like Mauritius and so on and so forth. First, now, parking funds abroad without concealing income does not contravene the Income Tax Act. If you do not conceal your income, then you haven't violated the Income Tax Act. So the issue is of concealment of income by an Indian, whether in India or abroad. So the question is, the destination does not matter in the Income Tax Act. There the FEMA and the Prevention of Money Laundering Act comes in. But wait, now if you have found under the Income Tax Act to have concealed your income, then you are given an additional tax, you can be levied an interest, a penalty, you can even be prosecuted. But every concealment does not necessarily lead to prosecution because the income tax authorities have a certain discretionary power and they exercise that discretion whether to prosecute or not depending on what they consider is a gravity of the situation. So, in other words, you can tend to pick and choose names and this could be politically motivated or you may or may not here look at politics in that sense. Now wait, several questions are raised by Mr. Bhattacharya in his article. Let me raise them because they're very, very important.
Quickly.
When was the foreign account?
Other issues
when was the account opened? If it was opened when a person was a non-resident Indian under FEMA, then he is entitled to maintain that account for the rest of his life. 2, was that account opened with the permission of the Reserve Bank of India? Then, again, you're not violating the law. Again, if the funds have been generated abroad and you have accounted for it, again, you're not violating the law. So, are you...
Absolutely.
So the whole set of issues, and also we can come to this, and if you like, I can talk to you a little bit.
We'll come to that later. Yeah, the question now is this, that when the government discloses these names tomorrow, they will have... have they gone through all these tests which Paranjoy was talking about each account? Or if it is not, then who should do it and whether it is the right thing to do? Mr. Virmani, first I'll come to you.
Two things. One is just to finish off what Paranjoy was saying. You know, there's one aspect we haven't discussed, which is money generated through corruption. Bribery itself is a crime both in India and now increasingly even bribing Indian officials is a crime in many countries. So we can come back to that if you like.
No, but the question is that if you're talking of corruption, is this corruption money?
We don't know. That comes to your second question. We don't know. Yeah. So that is the whole point about investigation. So is there a crime committed? There has to be, you know, again, the legal person is better, but is there to be some kind of prima facie case against that person before we take further action on this and disclose or whatever is what my understanding is.
No, Sanjay Hegde, the question is this.
That's the process which has been going on but is not completed.
When the Supreme Court made this very stern and harsh remarks today saying that the new government cannot, try to fool us, they have to tell us, give us all information. What is the Supreme Court trying to say? Is it aware of the fact that all these things need to be done before it goes before that?
You can take it from me that the Supreme Court is aware of all these. But right now, the question is that the government has data. This government, the previous government. Has somebody been selectively using the data? Has somebody been selectively investigating some cases, not investing certain cases? Or has the government just been sitting on the list and doing nothing? That is what the Supreme Court really probably wants to know. Therefore, it has first asked, please give us all the names in a sealed cover. That ensures one thing, that there can be no further manipulation.
If there is any. If there has been any.
That all the data that the government has is also available in secrecy with another authority. Thereafter, what action? It would probably work through the SIT.
No, we will leave this, sir. We will leave this aside for some time, because let's get to the real issue. The real issue of black money. The whole issue has been so politicized in this country that there have been all kinds of fantastic figures being given. A former CBI director had said that $500 billion is what is stashed abroad by Indians and things like that. No, but the question is this. This whole black money.
Yes.
And I was reading one of your interviews and what you have been saying. There is more black money in India than abroad. Right?
So basically my argument has been that the black economy in the country has been growing. Caldor came in 1955-56, estimated as 4 to 5% of GDP. And then there have been various other studies like Vanchu and NIPFP and then my own study. And now my estimate is more than 50% of GDP.
50% of GDP
would be roughly 65 lakh crores this year.
Is black economy.
Yeah, and of that 10% goes abroad. 90% stays here. And of the 10% that goes abroad, a part comes back as a round tripping. So not all the...
One second, 65 lakh crores you said is the GDP.
Black income generation.
Is the black income generation.
Annually at the current point.
And 10% of it goes
abroad. So
which means about 6.5 lakh
crores goes abroad, of which a part comes back through round tripping. Another part is consumed abroad. Another part is invested abroad. And therefore, what is left as liquid funds, which are in banks, is a very small amount. So the estimate that was made by the Global Financial Integrity for the data from 48 to 2008 suggested that $462 billion was the opportunity cost of the funds that have gone abroad. Okay, so opportunity cost means including the interest that would have been earned on it if it was all deposited in the banks, but not all of it was deposited in the banks. Now, what the CBI director did was that he upped it to 2010 and added another $32 billion and made it into $500 billion.
He made a round figure of it.
Yeah, so we are doing a study on tax havens in the world, and our estimate is that the opportunity cost of the funds roughly is about $1.2 trillion, because what the Global Financial Integrity did was to leave out under-invoicing and over-invoicing of services. It left out transfer pricing. It left out criminal money like, narcotic drug trafficking and so on and so forth. So our estimate currently is hovering around $1.2 trillion.
$1.2 trillion of Indian money which is out.
Which is opportunity cost, which is not the amount of funds available there.
Okay,
yeah,
Mr. Virmani.
I
want you to give some perspective on this.
I want to give a picture to the public. Yeah,
absolutely.
It's very important to be clear that there are two things. One is an income, and the other is saving converted to an asset. And the studies I have seen, I'm not talking about his particular study, there is complete confusion. People don't keep these apart.
Yes.
One,
and, people are waiting for 15 lakhs
on the income
in each,
side,
everybody's account.
Let me make a point which has not come up, which is that I believe the nature of the generation of the black money has changed drastically over the last 20 years. It's not what we conventionally think of as tax evasion by people like you and me.
Or corruption money.
It's much more the public sector corruption and the government corruption in expenditure. If you see the expenditure GDP ratio, just to give you an idea, I believe that 30% of that goes into corruption, which would all become black money.
Exactly.
One. Second point on assets. If you look at a distribution, it is not only rich people who are earning or evading or corrupt. There are also a lot of people down to the village level who are corrupt, right? So they are not saving.
All of us, one second, all of us generate black money.
That's right.
All of us,
don't save it. That's right. We just spend most of it.
Exactly.
Please, one second. So my point is that it's only the top, if you think of a normal income distribution, there will be also an income distribution of black money, conceptually, right? It will only be the top, 10, 15, 20% who are actually doing the saving. The rest are just earning it and spending it, right? So you have to be very careful about this. That's my main point. Now, the rest of it, I agree. Let's say it's the top 20%. Much of it is connected to land actually, right? And then some of it, those proportions may be right, I don't disagree, may go abroad. but it's a small fraction of what is invested in.
I'd like to correct the impression. You see, in India, roughly 1% of the population pays income tax.
Right.
Okay, even though 3% file income tax return, but of that 2% file either nil return or very low return. So our tax base is very narrow, and as we all know that the income distribution is log normal, which is something which rises very rapidly and decreases very quickly because there are very few rich people in the country. And according to my estimate, the bulk of the black income generation is concentrated in the hands of 3% of the population, because bulk of our population is the unorganized sector.
Absolutely.
And the unorganized sector has very low income. 50% of the workforce is in agriculture. Okay, so therefore we can't say that it's distributed like the white economy. It's actually much more narrowly concentrated.
Actually.
And that's where the big assets creation is, and that's where the flow out from the country takes place. The big businessmen, the corrupt politicians, the corrupt bureaucrats, the corrupt policemen, the professional class, it's their big income. And that's why I would say BCCI Bank, when it failed in 1991, you found even small businessmen had funds abroad in the BCCI Bank, which they lost. So it's a very narrow base for the black economy.
Paranjoy, the question is the politicization of this entire issue. Now, the present government finds itself in a position where it has to justify a lot of things which it had claimed. There are a lot of problems which the previous government had faced because of this issue. Now, you think that in this kind of an atmosphere which has completely got polluted by politicization, any clarity can come into this issue?
The problem, Girish, is when you politicize a situation like this, when you ask to become answerable, that's when the problem. You see, the law hasn't changed between the UPA and the NDA government,
right,
between Dr. Manmohan Singh and Mr. Narendra Modi. It's just that the impression that was sought to be given by the Bharatiya Janata Party and its leaders in the run-up to the elections and others, ideologues of the BJP and the RSS, gave an impression, including Mr. Advani, including Mr. Gurumurthy, that, once this government would come to power, it would bring back all this ill-gotten money, and that would do wonders to the Indian economy, and we'd be sort of distributing it and sort of rejuvenating every village and giving it to the poor. Now, all of this was just rhetoric and just tall claims. And this is what the government realizes when it is in power. Because then now it is taking a position which is no different from what the UPA government
that is the point.
It's exactly the same set of double taxation avoidance treaties, it's the same Income Tax Act, it's the same Foreign Exchange Management Act, it's the same Prevention of Money Laundering Act. And let's accept one other thing. We give such a lot of importance to this. As Professor Arun Kumar rightly has pointed out, and Dr. Virmani, the bulk of the black money that is being generated is here within your economy, in your country. So when you're looking at concealment of income outside, what about concealment of income within India?
Absolutely. Sanjay, I agree. That is the question is that laws have not changed, that same laws, the same argument which the UPA government had put forth before the Supreme Court, this government is also putting forth before the Supreme Court. But now the Supreme Court doesn't seem to agree with it. What will happen? So is there a problem that at some point of time we'll need to have a relook at the law itself?
That relooking at the law is always for the government of the day. But as far as the Supreme Court is concerned, you must realize that that is a process which has been an ongoing process, irrespective of the government. When the petition was first filed by Mr. Jethmalani, the Supreme Court asked the government of the day, that was the UPA government, what it proposed. And it was in fact the Solicitor General Gopal Subramaniam, whose idea it was first to bring in an SIT.
Okay.
And then the Supreme Court appointed a former judge. It gave a very detailed judgment through Justice Reddy, who's now retired.
My question is this: the laws remain the same. The arguments remain the same of two different governments. Then now, what happened? We'll have to wait and watch, because as far as the legal issues are concerned, it's not clear as of now.
The laws remain the same. The personalities and the names, that is where the Supreme Court is currently fixated.
Yes, Mr. Virmani, my question is this: that after all this, generation of black money, no government, in this entire politicization of the issue, the black economy which prevails here, as he says, 50% of the GDP, 90% of it here, that has not been tackled effectively by any government so far.
Yeah, so the one issue is the generation of black money, right? What should we do about that? What are the
how
kind
have
of
we,
things?
how, you know, we have to
Now,
hit at the...
there are a number of things. I just want to mention one and then address the kind of related question which you had raised.
Quickly, because
one simple one is, of course, changing the policies, rules and regulations. I mean, for example, we know that in recent years, the way of allocation of natural resources, you know, whether it's coal or any other thing.
2G
and this has been known. I mean, I wrote an article on this 20 years ago on Spectrum, or less than that, 15 years ago on Spectrum, saying that we should auction it. But it's taken 15 years to change it. So there are many policies like that. If you make them better, you will have less. It won't disappear.
It won't disappear.
You know, I'd like to quickly add to what people have said. One is, you see, why are we not prosecuting HSBC? HSBC is the one which operated as a Hawala operator, taking funds out of India and bringing it back. Similarly, other multinational banks are also doing the same thing. They act as Hawala operators for their high net worth individuals. We are not doing that.
We have seen one of the sting operations of these banks.
No, forget sting operations. Now there are actual statements from the people who have caught the income tax, you know, has found that out. The second is Hawala operations in India can be stopped in 5 minutes. The intelligence agencies are tracking where Hawala takes place from Chandni Chowk and from farmhouses of Delhi and from Bhendi Bazaar and from, you know, Pune. This Hassan Ali case is, you know, one of Hawala operations. We know where it takes place, and intelligence agencies track them. If the PM wants, in 5 minutes, he can order that they be raided and closed and the information grabbed. That's what happened in the Jain Hawala case, where 52 politicians' name came out because you grabbed the information immediately. Now, Hassan Ali case in 2007, you did not do anything for 4 years. So the money just went, and when Pranab Mukherjee in his press conference said only $60,000 is left out of the $8 billion, now no Hawala operator is a fool to leave the money on his hard disk or in his bank account. Right? So we have to have quick action.
No, apart from that, there are fundamental problems in the way
I'm
we
not
do
going into the details of the other proposals because, you know, the time is short, as you said. So that's why I'm suggesting additional steps that could be immediately taken, which would have a salutary effect on the particular process that we're talking about in the SIT, in the banks, and in the courts. Of course, there are many other steps that could be taken, but I think these are critical for what we are discussing.
Would you agree with that?
Yeah, see, I was more concerned about the earlier statement about, you know, on HSBC. What was your point?
HSBC
Sorry.
was the...
Yeah, no.
About the league...
naming, on getting the names out.
Yeah, okay, yeah. The corruption issue, I think the SIT, you know, the politics is obviously clearly involved in the corruption issue, right? So my guess, again, as an economist, is that that is what the Supreme Court is, or at least should be concerned about. You know, the prosecution of just plain tax evasion is the job of the government.
Absolutely, very quick.
And therefore, they are monitoring it to ensure that, because the politics is biased. So when there was a Congress government, they would go soft. I mean, there's no mystery about that. They would go soft on people connected with their own. Similarly, any new government with different... Again, so that is where the SIT comes in my view, where they have a legitimate role.
Very quick last words.
2 points. The first is a legal point. Given the state of the laws of the land, there are the yardsticks for determining the residential status are different from under the Income Tax Act and under the Foreign Exchange Management Act. And this is what Mr. Bhattacharya has pointed out in his article. Secondly, about repatriation of funds. You know, does an income tax officer, an assessing officer, does he have the power to repatriate? No, but the enforcement directorate has the plan. But at the end of the day, the government has to proceed and has to expeditiously conclude different inquiries, whether it be the enforcement directorate or the income tax department. I think the key point which Professor Arun Kumar made and also Dr. Virmani alluded to is that, look, this whole issue of political will, there is a nexus between business, politics and crime, including Hawala operations in this country. Yes, you have deliberately have a series of loopholes and infirmities in the law because at the end of the day, this is how political parties and elections are funded.
Quickly, I'd point to the Birkenfeld UBS case in which Mr. Birkenfeld was traveling between Zurich and New York and he was tracked by the income tax authorities, and on that basis, they actually trapped several people who he was visiting and who were taking money out to the US bank. And therefore, they fined UBS Bank $750 million and they got 4,500 names on small information. So SIT will be very useful for that.
Okay, and on that note, we need to end. The fact of the matter, this is a debate which will continue. But what needs to be done as far as controlling black money or black economy is not just these big things which we keep hearing, but effective steps taken by the government, whether and a political will to take those effective steps. We'll have to wait and watch whether it will happen. But this debate will continue because it is something which the entire country is looking forward to. Thanks to all my guests, Professor Arun, Kumar, Mr. Arvind, Virmani, Sanjay, Hegde, and Paranjoy, Guha, Thakurta. Please keep watching. We'll come back with another issue on Big Picture same time.